Welcome everyone to Foley's Staying Competitive and Compliant in the EU webinar. My name is David Pulio and I'm a staff member with Foley and Lardner's marketing department. On behalf of Foley, I'd like to thank you for joining us here today with our conference. Before we begin, we do have a couple of brief housekeeping announcements. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget, which is open on the left-hand side of your screen. We will respond to written questions at the end of the program. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience any technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window. It's designated with a question mark icon. The PowerPoint presentation will be available on our website at Foley.com in the next few days, or you can also obtain a copy of the slides in the resource list widget, which is open on the left-hand side of your screen. As a reminder, today's program is being recorded and will also be available on Foley's website within the next few days. Foley will apply for CLE credit after this web conference. If you did not supply your CLE information when registering, please send an email to me, David Pulio, at dpulio@foley.com. To be eligible for CLE, you will need to be logged into this webinar on a computer and answer a polling question posted sometime during the program. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete an attorney affirmation form in addition to the polling question that will appear during the program. Please email this form again to myself, David Pulio, dpulio@foley.com, immediately following the program. Now I'd like to introduce our speakers for today. Howard Fote is a partner and a member of Foley's antitrust and international practices, as well as the automotive and life sciences industry teams. Mr. Fote has counseled and represented clients in a multitude of international and domestic matters, including international antitrust, distribution and franchise matters, multinational mergers, and the law of the European Economic Community. We also have with us Sophie Lignier. Sophie Lignier is of counsel with Foley and is a member of our antitrust and international practices. Ms. Lignier practices European Union law with a focus on regulatory issues and possesses extensive knowledge in that area from her time spent working for the European Commission on the regional and local implications of EU economic policy. Also joining us today via phone is Scott Fredrickson. Scott Fredrickson is a partner and member of Foley's governance, enforcement, compliance, and white-collar defense practice, where he focuses on white-collar criminal defense, antitrust, export control matters, and FCPA claims. Mr. Fredrickson brings over 30 years of litigation experience to the firm, including time spent both as an independent counsel and a federal prosecutor. And finally, we have Alan Rutenberg. Alan Rutenberg is a partner and the chair of Foley's antitrust practice. Mr. Rutenberg has advised clients in hundreds of mergers and acquisition matters and actively counsels on a variety of topics, including compliance matters, competitor collaborations, and the Hart-Scott-Rodino Act. In addition, Mr. Rutenberg regularly represents clients before the Antitrust Division of the Department of Justice and the Federal Trade Commission. At this time, I'll hand things over to Howard Fote to begin the presentation. Thank you all and have a wonderful conference.
Thank you, David, and good morning, good afternoon, good evening to all who have joined the call. Thank you, as David said, for joining this 9th in the series of annual webinars that the Foley Antitrust team has provided on important competition issues posed for companies doing business in the EU. As the slide indicates, the prior conferences have focused on EU basic principles, as we will do so again today, with a special emphasis on the role of competition policy in the creation of the single market, European Commission and European member state mergers, merger control policies and procedures, as well as a focus particularly on vertical restraints in terms of distribution, cartels, competitor collaborations, trends and developments in European competition law, important private remedy developments, as well as best practices for compliance. Let's start with a slide that is probably familiar to those of you who have attended these webinars in the past. We're going to focus on basic competition principles, why they remain important, and what lies ahead. We will discuss, and Alan Ruttenberg will lead the discussion on merger developments, both at the EU and member state levels. Sophie Lignier will focus our attention on important distribution questions, particularly as they impact on the creation of a single European market. She and Scott Fredrickson will talk about recent developments in cartel enforcement. I will focus on horizontal cooperation and will have a particular focus on information exchanges and important developments relating to facilitation and collusion. Sophie will review a number of important legislative developments, including a pending Commission legislative proposal that may bring significantly increased procedural harmonization of anti-competition enforcement. We'll focus as well on private enforcement developments and then on competition compliance and important differences between the United States and the European Union. As many of you, I am sure, know, the goals and the structure of the European Union, now over 50 years in age, was intended to create an integrated common economic market, replacing a patchwork series of national trade restraints. To that end, European legislation has eliminated most intra-European custom duties, quantitative restrictions, and has imposed a common commercial policy toward third countries. Critical to the success of the creation of a single market has been the concept of free movement of goods, people, services, and capital. To that end, a system of competition principles and procedures has been established, working at EU and member state level. For the first many years, focus of competition in the European Union was at the European Union level. However, in 2004, there was a significant devolution, providing for the direct application of competition principles to national courts and competition authorities. We're going to look at the process and the progress over the last half century and give a report card at the end of our session. Suffice to say, it is very much a work in process, an evolution in a union of 28 widely diverse member states. Speaking fundamentally, European competition basics and principles prohibit horizontal and vertical restraints, much like the United States. They prohibit cartels. They prohibit resale price maintenance. They regulate abuses of dominant position. Perhaps unlike the United States, they are focusing on state aids, finance support by member state governments that may give a particular competitor an unfair competitive advantage and thus undercut the goal of a single European market. Increasingly, there have been steps to assure that there is active and ongoing cooperation between EU and member states in regulating anti-competitive behavior and promoting the creation and sustaining of this internal free market. Any analysis of competition basics in the European Union requires an understanding of the legislative process, the interrelationship between and among key institutions, the European Council, the European Parliament, and the Commission, as well as the member states who act as not only advisors but integral players in the competition process. There is a myriad of legislation that is created and put into effect by the European authorities, and it's important to understand the differences between these legislative enactments. There are regulations. There are regulations that are issued by the Council, by the Commission. There are decisions of the Commission that have binding effect on the parties before them. There are directives from the Commission and the Council that have binding effect on member states and require member states to enact legislation consistent with the terms of the directives. There are, like in the United States, notice and guidelines that give important information and, as the term guidelines implies, guidance on how European law is going to be conducted and enforced and interpreted. Over the course of the years, as I've mentioned, there is increasingly greater responsibility on the part of national competition authorities and national courts to interpret and enforce the competition principles in the European Union. Significantly, there are strong trends toward what we call subsidiarity, which is to devolve authority and power and resources to the member states in these areas. And as you might expect, this has produced a growing tension between efforts to achieve greater harmonization among the 28 member states and those member states' desire for increased local control. Let's turn now to the issue of merger regulation, and we will focus on this issue first from a European community level. There is a merger regulation, the European Merger Control Regulation, that functions, as Alan will explain, in a manner very similar to the Hart-Scott-Rodino legislation in the United States. That is to say, certain mergers of a certain size are required to be notified to the European Commission, and a waiting period is imposed before the transaction can be closed. Unlike the Hart-Scott-Rodino procedures, the notification triggers in the European Union are substantially larger, much larger than in the United States, and perhaps Alan can give us some specifics on that. So that only transactions that that have a community dimension are notifiable to the European Commission. There is an initial phase 1 waiting period within which the Commission evaluates the transaction that has been notified, and then there is an opportunity for a phase 2 procedure similar to a second request under Hart-Scott. The presentation refers to a number of opportunities for case referrals and discusses the division of competency between member states and the European Commission. And as you will see at the top of this slide, there is a citation to the Merger Control Regulation, so that if you need to understand the size of person and transaction tests, the ability of the parties as well as the national competition authorities to seek authority to investigate a transaction, that regulation and those legislations will help you understand the basic legal underpinnings for merger control regulation in the European Union. Beyond the European Union, there is increased cooperation between and among antitrust authorities around the world as transactions of a global stature are evaluated pursuant to increasing numbers of bilateral and multilateral agreements among authorities to provide for the procedures that are used in evaluating these important transactions. I'm going to turn it now over to Alan Ruttenberg, who will talk with us about some of the important recent statistical trends.
Thank you, Howard. So looking on slide 10, you'll see that over the last several years, there's been an uptick in filings within the EU merger control regime. I think this, in general, reflects global trends with the recovery of the economy following the 2007-2008 downturn. It also reflects the global increase in M&A activity over the last few years. Looking at filing statistics in some places around the world, the number of filings at the EU level are relatively small, particularly compared to filings in the United States under the Hart-Scott-Rodino Act. For the last full year for which there are HSR statistics, the fiscal year that ended in 2014, there were 1,663 HSR filings compared to 303 at the EU. So, more than, the EU filings account for less than a fifth of the volume of the HSR filings. That's explainable in a number of ways. Both set objective criteria for reportability, which oftentimes captures deals that are non-problematic, but the thresholds in the United States are much lower. The HSR thresholds typically look at the size of the transaction, and for deals of certain sizes, also the size of the parties involved. The EU thresholds are also numeric-based, but much larger in nature, looking at both global turnover and turnover of the parties within the EU. There are a couple different alternative thresholds, but again, much higher. That doesn't mean in absolute terms there's less merger review or enforcement within the borders of the EU or the EEA, in that there are national competition authorities such that there are many transactions that are not reportable because of size or community dimension that get reviewed at the local competition authority level. And with one or two exceptions, almost all of the EU EEA members have their own competition regimes. But again, for deals of a certain size and a certain dimension, this is meant to be one-stop shopping. If you look at there are ways that even if a transaction meets a community dimension, that if it makes more sense, it can get reviewed at a member state level. There's a process where pre-notification parties can request that the commission refer it back to a member state. There's also a process where post-notification the member state can ask that the commission refer it back to the state. The relative number of referral requests are pretty small, but I think we show in this report that there were 13 requests by parties, 12 of which occurred, 3 by member states which were refused. The numbers aren't big, but I think there's a sense that there is some friction and perhaps a growing friction between the member states' competition authorities, many of which are experienced and quite sophisticated, and the EC. Just to give you an example of a recent one, a telecommunications transaction that was announced between Hutchinson and Telefonica in the UK. In December 2015, the EC decided not to refer the planned acquisition to the UK Competition Authority despite its request. The Commission concluded it was better for them to do it at the Commission level to ensure consistency. And partly that may be driven by the nature of the transaction, that it was telecommunications in nature. Similar to an outcome with the Spanish Competition Authority on another transaction earlier in the year involving Jazztel and Orange. But just as a recent example of it going the other way, at the party's request, the very large retail food transaction merger between Royal, Ahold, and Delhaize was referred back to the Belgian Competition Authority. If you look at the statistics on the middle of the slide, you'll see that most transactions, you'll see 297 out of 337 last year get cleared within the first phase. The first phase is a 25-day working period, although it can be extended by 10 working days where parties offer commitments, which are remedies such as divestitures. That doesn't tell you the whole timing story if you're trying to plan your merger, because it is routine and almost always used as a practice in the EU that parties will have consultations and dialogue with the staff before there's a filing. So the time period doesn't actually start until after the filing is accepted. But we know that of the 297, 222 of these were cleared under what are called a simplified procedure for deals that are viewed as likely to be less problematic, that can use a short form filing that's less of a burden, requires less information. And a small number of transactions, 13, were cleared in this first phase with commitment, so some types of remedy offer or divestiture. A relatively small number of deals each year go into what's called a phase 2, which is a much more in-depth investigation, 11 in the past year. And of those, if you look historically over the past several years, most transactions that go into phase 2, there's typically, from the statistics going back several years, a decent chance that if the deal is going to be cleared, it's going to be cleared with conditions. For the last couple of years, there have been no deals that have been outright prohibited. If you look back statistically in the course of the merger controls history back to 1990, only 24 deals have been prohibited outright. Although that does not reflect that there are occasions, including at least one occasion in the past year, where parties sometimes abandon and walk away from a deal before it's prohibited in the face of Commission concern.
Alan, this is Howard again. Could I ask you a question that may be relevant to some of our participants, and that is that if we look at the number of phase 2 investigations that are initiated, for example, in 2015 it was 11, and compare that to the percentage of second requests that are initiated under the Hart-Scott-Rodino process, would it be fair to say that the percentage is roughly the same? It's obviously not exactly the same, but it seemed to me important to recognize that while in the United States, roughly 3% of notified transactions get a second request, the number in the EU, interestingly, is roughly comparable. Is that a fair statement?
Yeah, I mean, they're not identical, but roughly, single digits in both for sure. What may not be reflected in that statistics is it is more common, I believe, in the EU than the United States that there might be some type of remedy resolution without going into it. It's more common that you could have that in the EU without going into a phase 2 by resolving it in phase 1 than in the United States, where it'd be more typical that transactions with a remedy at the end of the day will have gone into a second request.
Right. Let's move to the next slide then. And I think you, Alan, have dealt with some of the issues on this slide, the Hutchison 02 and the Belgian grocery store merger development. I wanted to emphasize before we moved to the next topic, that increasingly, perhaps increasingly like again in the United States, there is a strong bias on the part of the regulator to insist upon upfront fix-it-first remedies. As Alan alluded to, the process in the EU is slightly different in the United States, in that in the EU, parties are required to have pre-notification discussions with the merger task force, the result of which may well be to crystallize important issues before the notification is made, and if the parties desire and the Commission is willing, result in a fix-it-first upfront clearance in Phase 1 rather than under Hart-Scott, which, as Alan correctly says, typically occurs in a second request context. I guess I would emphasize again that the EU and the U.S., among many other regulatory authorities, are cooperating actively, either bilaterally or multilaterally. There is the International Competition Network, which now has more than 30 countries that are members of it, and is a focus for and a vehicle through which cooperation can be actively undertaken in merger investigations. To the extent that one becomes involved in those kinds of transactions, there may well be requests from the regulators for parties to waive what would otherwise be rights to protect the confidentiality of the filings they've made with the merger control authority. You need to carefully balance the interests of your client in terms of protecting its data from scrutiny by another regulator, and so it may well be the case, particularly if there are questions whether the authority requesting the waiver has the right to investigate, that you protect the confidentiality of the data and decline to provide that waiver. I guess the final point that I would make on mergers is that the Commission has been actively considering the question whether notification should be required in the event that there is an acquisition of a minority share interest. And that's been highly controversial, and in the EU has been now put on a back burner because of that confidentiality. On the other hand, Brazil, as an example, is a country that has recently adopted such a minority share interest notification requirement, and it will remain to be seen what the implications of that are in terms of its interpretation, its enforcement, and the extent to which it successfully achieves the goals of the merger authority in Brazil. I'm going to turn it now over to Sophie Lignet to talk about vertical restraints and in particular on online distribution.
Thank you, Howard. Yes, we're going to focus on online distribution. That, as you may know, the European Commission decided to open a competition sector inquiry into the e-commerce sector last May. E-commerce is at the top of the Commission's agenda, and also several member states, and in particular Germany, have been already quite active on this issue. So what are sector inquiries? Those are general investigations into the entire industry sector. And in such inquiries, what the Commission is doing is it's basically the same as the same investigatory powers as any other cartel investigation. So the information obtained can also be used to initiate enforcement actions against individual companies. In this sector inquiry, what the Commission is concerned about is that the companies are taking measures to restrict cross-border e-commerce. And as explained in the Commission's press release, is the inquiry is focusing on distribution contracts on the cross-border sale of goods and services and digital content. Of particular concern is the issue of geo-blocking or rerouting of the customers to local websites. Interestingly, in a speech, the Competition Commissioner reported that out of the total amount of consumers, EU consumers buying online, only 15% of them buy online in another member states. And so suggesting, says the Commission, that there are potential barriers to competition. But also there are a number of other vertical restrictions, several of which have been already under investigation by the national competition authorities, and which are resale price maintenance for online sales, also restrictions to advertise price online, restriction to advertise product on price search engines, restrictions on online sales, which are not overall equivalent to any restrictions imposed on offline sales. The main EU Competition rules on which the Commission relies in the context of this inquiry are contained in the Commission's vertical agreement block exemption regulations and the accompanying guidelines. What the regulation allows is that some restrictions on active sales across national borders within the EU, however, does not permit restrictions on passive sales. Passive sales are the sales made in response to unsolicited orders. And the guidelines that respect make it clear that Internet selling is generally viewed as passive sales, and therefore it cannot be restricted. The EU guidelines also made it clear that various related contractual measures also infringe competition rules, such as provisions concerning differential prices for Internet sales as compared with the sales in physical outlets. We give here on this slide further examples. But just to conclude is that there is a fundamental principle in EU law that every distributor must be allowed to use the Internet to sell its products. The Commission is already investigating various cases of alleged infringement in online selling, including an investigation of restrictions on pricing and cross-border trading via the Internet of consumer electronics products. There is also an investigation on geo-blocking of video games sold online. So the first result of this inquiry are expected to be published before the summer break. Also, the final report is not expected before next year, the first quarter 2017. And if the inquiry reveals some malfunctions in the market, the Commission then is likely to rethink its enforcement priorities and could initiate separate investigation against individual companies or adapt the legal framework and, for example, by initiating legislative changes. Let's move now to the cartel sections with some statistics. On this slide, you see the total amount of fines which have been imposed by the European Commission this year in comparison with the previous year. The next slide shows you the number of cartel decisions taken by the Commission, 5 cartel decisions this year on a total of 23 undertakings. So to just as an overview as to those what happened in terms of cartel, this year marks the first full year of the Competition Commissioner and shows that there has been some non-insignificant amount of fines adopted in the EU with a total amount of 364.5 million euros. These decisions were taken in 5 cartels involving 23 undertakings, and they were in widely diverse industries, including the finance sector, automotive industry, the largest fines were imposed on manufacturers and distributors of retail food packaging trays and optical disc drive manufacturers. In 2015, as you've seen in the first slide, there were less cartel decisions, 5 as opposed to 10 last year, and also a reduced amount of fine. However, this decline on this total amount of annual fines is in no way an indication of reduced priority. As you may know, there are several ongoing investigations made by the Commission, and some examples include the biofuel sector, but also many investigations in the automotive sector with occupant safety systems, thermal and exhaust systems. So there is, it shows that many more decisions are expected. Some comments on all these decisions is that we can say that there is a continued success of the EU leniency program. Most of the decisions were based on immunity applications. And for those that were first to reveal the existence of the cartel to the Commission, they received full immunity. And other companies received a deduction for their cooperation with the Commission under the leniency notice. In that respect, I would like to highlight a recent ruling showing an important issue on leniency applications. It shows in that ruling it was recalled that EU and national leniency applications remain separate and independent, meaning that it could happen for the same cartel that the EU grants full immunity, while a member state could only grant a reduction in the overall fine, but not full immunity. So when a cartel member is coming clean, it should make sure that it applies for leniency in every jurisdiction where its anti-competitive actions had effect, and should adapt its leniency application to the local requirements where it applies for leniency. So as opposed to contrary to EU merger control system, there is no one-stop shop principle applying to leniency applications. Also now turning to, there were also cartel settlement procedures this year, and they allow as well to get reduction in the fines for the parties that admits the Commission's objections, and they receive in turn a 10% reduction in the fine. Again, the aim of this procedure is to simplify, speeden, and shorten the procedure. There were a total of 19 cases which have been settled since the introduction of the settlement procedure, and 2 of them last year in the parking heater and cargo block train cartels. Now I'd like to turn to some the activities of the courts, and there were some important rulings. First one that I will highlight very briefly, since my colleague is going to discuss it in the next section, is on information exchange, where the court made it clear that there is absolute no tolerance for sharing future pricing related information with competitors. It was in the banana cartel where the General Court confirmed that the Commission was correct in qualifying the exchange of information as a by-object restriction. Turning to parental liability, interesting rulings as well. One of them is clarifying that the anti-competitive conduct of a full-function joint venture with a separate legal personality can still be attributed to the parent companies. However, in another ruling, the court clarifies that the liability of the parent company cannot exceed that of its subsidiary. In this ruling, it is the court held that a parent and its subsidiary, when they each bring parallel actions against a Commission decision having the same object, then the parent can benefit from any reduction in liability of the subsidiary. Another interesting ruling relates to fine calculations made by the court. It was in the LCD cartel, specifically covering vertically integrated undertakings. The court dismissed entirely the appeal and confirmed that when cartelized products have been incorporated into finished products by a vertically integrated undertaking, then the Commission is allowed to take into account the sales of the finished products made in the EEA to independent third-party undertaking. So rejected completely the appeal in that respect. And finally, another yes.
Why don't we ask Scott Fredrickson at this time to give us some general guidance on cartel enforcement issues based on his extensive experience and responsibilities as a prosecutor and as a defense counsel in this area.
Thank you, Howard, and thank you, Sophie, for the wonderful insights. In my capacity as the senior white-collar criminal defense attorney partner in our Washington office, and after 12 years as a federal prosecutor with the Department of Justice, including as an independent prosecutor or special counsel, and then more recently I was appointed as an independent corporate monitor by the DOJ in our private capacity, we have seen the global reach of the enforcement authorities. And so in addition to all these wonderful insights and guidance we're hearing now, the one critical overlay that we would emphasize to keep in mind is the historically high levels of aggressive enforcement by first the U.S., of course, but also by the EU constituent members and, of course, the U.K. This aggressive enforcement has been led by and continues to be led by the U.S. DOJ, which is of the view that there's no place on this planet that its jurisdiction does not reach. And indeed, they continue to prove that's the case. In the cases we've been directly involved in, and that would include the LIBOR and Euribor, where the U.S. DOJ Antitrust Division and other constituent members of DOJ and agencies, as well as the UK and constituent members of the EU are involved in, that continues to this day and probably marks the high water mark of cooperation between the U.S. DOJ and the authorities I've just mentioned, both EU members and the UK. We've also seen it in the largest DOJ antitrust criminal investigation in their history, which is not yet concluded. The auto parts investigation focused on Japanese companies, but has drawn in companies from EU members as well. And we see it whether in the Volkswagen case investigation, FIFA, and other areas. So I think the critical overlay that we always emphasize is to always keep in mind that the U.S. has led the way in aggressive enforcement using their criminal laws as a means of reaching out and achieving jurisdiction and enforcing its laws. And in their success, they have paved the way for constituent members of the EU and the UK to follow suit and now cooperate with DOJ. So that would be the critical overlay in any analysis for us always to keep in mind.
Thank you very much, Scott. Let's move now to the next issue, which is horizontal cooperation and particularly information exchanges and collusion, which follows naturally from a discussion of cartels. And we will not have time today to review in detail all of the various slides that relate to information exchanges. Suffice to say that there are EU guidelines for horizontal cooperation that make it very clear that exchange of information among competitors, whether done privately in the context of a sub-rosa cartel or publicly through exchange of public announcements, can, if it reduces as the Commission says, the strategic uncertainty around future commercial policy, there is a likelihood that the Commission will investigate, particularly if there is an amnesty or an immunity application, and if it determines that there is the altering of the competitive process as the result of information exchanges, it can be problematic for the companies involved. Two issues are important to emphasize. First, this year, for the first time, a non-participant in a cartel, a trade association, AC Treuhand, was found liable for facilitating the collusive behavior. And secondly, it's important to reiterate that under EU law, even one simple exchange of pricing information can violate EU laws, as was confirmed by the Court of Justice in the T-Mobile case. The next several slides focus on some of the basic elements of how the Commission judges whether an information exchange is problematic. Is the information strategic, i.e. pricing information? Is it disaggregated and individualized? Does it relate to the future? Does it relate to the past? Indeed, even past historic non-price information can be problematic. Obviously, market structure plays a very important role in deciding whether the conduct is having the anti-competitive and illegal effect of altering competition procedure, altering the way in which competition operates. I want to spend a couple of minutes on a very recent case called the Bananas case. It's centered on weekly bilateral telephone calls between banana suppliers in which they disclosed their future pricing intentions. There was no evidence of an agreement based on the disclosures by the participants. However, the Commission found that those calls constituted a coordination of their price-setting behavior, and assessed their conduct as a cartel. The Commission determined that those communications reduced the uncertainty with which each participant ultimately made its binding price decision, and that as a result, competition was adversely affected in that market. The result of which is that in this case, the decision was upheld by the General Court, the Intermediate Appellate Court in the European Union, and it remains to be seen whether the parties will take the case to the Court of Justice. For your consideration after the webinar, there are guidelines with respect to how several of these issues are to be considered, and I will not at this juncture do more than simply call your attention to this particular slide and to the horizontal cooperation guidelines which are available on the European Commission's Competition Directorate website. Sophie, why don't you talk briefly now about some legislative developments of importance?
Yeah, thank you, Herbert. I will, there are briefly, the first two updates are just minor changes brought to. One of them is an update of the Commission antitrust procedural rules to reflect the damages directive and limit the use of information obtained as part of Commission investigations. It says that leniency statements and settlement statements shall not be disclosed at any time in competition damages actions in the national courts. The other update concerns the explanatory note on down rates, where again there are no major changes, but the Commission clarifies that search private devices and media, such as tablet mobile phones, that are used for professional reasons can be searched when found on the premises. Another and more importantly development concerned a consultation seeking views on how national competition authorities should be given more effective tools to enforce the EU antitrust rules. It was unveiled in November, And the aim of this consultation is really to boost the enforcement powers of NCAs. The Commission wants to ensure that any differences in the procedural rules among the NCAs do not undermine level playing field for enforcing competition law in the EU. So this consultation basically focused on ensuring that all the national competition authorities have the right tool to detect and sanction breach of competition law. In terms of investigatory powers, it's an issue where all NCAs do not have the power to gather evidence on digital devices when carrying down rates. Another example is the Commission wants them to be in a position to impose effective fines. Again, all competition authorities do not have the possibility to fine cartelists for the full period of their participation in a cartel. There are also differences in the terms of the nature of the fines imposed and the method for calculating the fines. Another issue that they want to harmonize, ensuring that all NCAs have effective leniency rules, encouraging companies to come forward. And also they want to, one of the points highlighted by the Commission is that safeguarding the independence of the NCAs and ensuring that they have sufficient resources and staff. So this consultation is open until the 12th of February next month. And it is considering the inconsistencies and between the national agencies' powers and practices, it is, we expect, likely to result in a Commission proposal. Which is, however, unlikely to be released before the first quarter of next year. Now I'd like to turn briefly on private enforcement and say a few things. It has, over the past years, become an ever-present part of the European legal landscape. The damages directive needs to be implemented by the 28 member states by the end of this year, December 2016. So that means that for many of these member states, it will be a significant amendment to their national laws and regulation. And in particular, as you may know, in the EU, 3 of them are particularly regarded as being attractive jurisdictions for claimants: the UK, Germany, and the Netherlands. And in particular, the UK is one of the preferred jurisdictions for claimants because of the availability of disclosure. And also because of now in October, they have adopted a new Consumer Act, which introduces significant changes to, again, facilitate even more the claims by including the establishment of a fast-track procedure for simple claims, but also an opt-out collective action regime. So meaning that such a regime will be possible both for follow-on competition law claims, but as well as standalone competition law claims. In that respect, does not follow the EU recommendation, which I recommend in an opt-in collective action, but it's going to be a significant development, which should result in further cartel damages claims being brought in the UK. I will hand it over now to Howard for the next slide.
Thank you very much, Sophie. Let's conclude our substantive presentation with a brief discussion of EU antitrust compliance. What is it? Compliance obviously means obeying the law. Why comply? Many people feel it's good for business, particularly in the EU, which is one of the largest economic areas in the world. But what are the risks of non-compliance? We've seen in the cartel area that there can be substantial fines that can be imposed. While EU law is not criminal, the law in a number of member states, France, the UK, for example, have criminal competition laws, and there is an increasing emphasis on private damage remedies, as Sophie has just explained. Nevertheless, while compliance is essential, there are important differences between the EU and the United States, and companies who are intent on complying with the laws where they do business need to understand that one size doesn't fit all. There are at least 3 important differences between EU and U.S. compliance, for example. There is an important difference between the role of the carrot and the stick in terms of emphasizing the risks of noncompliance. There are significant differences between the 2 jurisdictions in affecting and achieving effective compliance. And then, as we have said in prior webinars, there are very important, significant differences in the way in which the attorney-client privilege operates in those between the United States and the EU. First, unlike the United States, the European Union gives a little credit for the same kind of effective, fulsome compliance that one would get in the United States. While both expect compliance, the EU provides a little tangible economic incentive for compliance, while the United States gives real credit for effective programs. The EU bases its finding decisions principally on the gravity and duration of the violation. A second important and major difference that perhaps is less well understood is that while many of the elements of a U.S. and an EU program might be the same, they differ substantially on the important issue of self-reporting and cooperation, whistleblowing and confidential hotlines. Those kinds of whistleblowing and confidential hotlines are essential parts of best practice U.S. compliance programs. In the EU, on the other hand, they are viewed as unlawful, unacceptable intrusions into the workplace, and violations of the right of privacy. Those attitudes reflect sharp cultural and historical differences between the United States and European privacy policies view confidential hotlines as pitting employees against each other. They are highly suspect. In addition, many EU member state labor protection laws further restrict the ability of companies to compel employees to participate in programs to facilitate legal compliance through means of hotlines and whistleblowing procedures. The result of all of that is that great care must be taken to avoid those potential minefields in attempting to expand from North America to the EU in terms of a compliance program. Finally, there is an important critical difference for all of the lawyers who are actively counseling and helping companies, whether as outside counsel or as inside counsel, deal with questions of the facts and developing the ability to represent the company or individuals in an investigation. In the United States, there has been a long, well-established, and robust privilege protecting confidential communications between an attorney and a client. Though that privilege applies to communications involving in-house and outside counsel in fact-gathering, in negotiations, or in trial preparation. The situation is very different in the EU for complex historical, cultural reasons which combine to limit the scope, when and to whom the privilege applies. As we have said before in prior webinars, there was a 2010 Court of Justice decision upholding an earlier General Court decision limiting dramatically the scope of the attorney-client privilege in competition matters, in cartel matters in particular. It said specifically that in-house counsel even if a member of a national bar, are viewed as economically dependent on their employer, and that they do not have the same degree of independence as external lawyers, and do not, as a result, have the right to have their communications with their employees protected by the attorney-client privilege. There are significant conditions for the application of the attorney-client privilege in the European Union, and the right of an in-house lawyer to maintain that privilege is greatly, greatly restricted, and that's an important issue that all need to be aware of as you are involved in either a European Commission or a member state investigation. Currently, the focus has been on cartel investigations. However, that risk may well spread to other competition matters, whether it be mergers or distribution agreements, and it may indeed move to other areas of regulatory scrutiny within the EU. Let's wrap up with, I'm sorry, David, do you want to have your code now?
Yes. At this time, I'm going to be reading the CLE code for this program. If you're in need of credit, I'll be stating a 5-digit code. Please enter this into the poll question in the presentation area here and click Submit. The code is Y8QBD. That's Y as in Yankee, 8, Q as in Quebec, B as in Bravo, D as in Delta. And again, if you're seeking CLE, please enter that code into the box in the presentation area and click Submit. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to entering this polling question, I will need you to fill out an attorney affirmation form. That form can be found in the resource list widget to the left of the presentation screen. It's also present in your confirmation notices and invitations. I'm going to leave this open for another 20 seconds. Oh, hang on. I'm going to leave this open for another 20 seconds or so here, and then we'll proceed with our concluding remarks. And one last time, the code is Y as in Yankee, the number 8, Q as in Quebec, B as in Bravo, D as in Delta. And at this time, I'll turn it back to our presenters for their concluding remarks. And I'd just like to thank everyone for attending. At the conclusion of this presentation, we have received a sizable number of questions from the attendees, so we will be following up with each of you individually to answer your questions. And at the conclusion, we will have a presentation evaluation form pop up for you. We do read these forms. We do strive to improve our presentation, so please take the time to fill that out. We would appreciate it. Thank you all.
Thank you, David. So let's conclude with some generalized comments and some predictions. The European competition laws are mature. They have tested numbers of decades of enforcement activity, and it seems to me that there are some conclusions that we can draw from the experience that has been observed. The Commission is going to retain authority on high-priority EU-wide issues, and there's no threat to its ability to take effective action for large mergers, cartels, and other issues of EU-wide importance. At the same time, there is increasing devolution of competition activity to national competition authorities and to national courts through private remedies. Importantly, since 2004, national competition authorities have made 85% of all decisions applying EU competition law, and that's going to have a tremendous impact on the way in which EU law in this area evolves and will be applied in the future. As Sophie has indicated, there are efforts at EU level and member state level to increase the ability and effectiveness of national competition authorities. as well as there are continuing efforts to provide for an effective private antitrust remedy in the EU and in the EU member states. There are important priority issues. If I were to single out one, I would say that e-commerce continues to be a very, very important issue in the European Union, as it directly affects the ability of the Commission and the European Union authorities to achieve the goal of the European Union, which is a single economic market. Obviously, from the foregoing, competition issues will remain a very high priority in terms of EU single market integration. On behalf of Sophie Ligné, Alan Ruttenberg, Scott Fredrickson, and myself, I want to thank you for attending this conference, and we will, as David indicated, be following up with answers to your questions. Thank you, David.